Good evening, everyone. Welcome to the Immigration Talk Show brought to you by Sakshi TV. My name is Ranjit. We are here today with the attorney Prashanti Reddy to discuss the latest updates on immigration, the I-140 process, followed by Q&A. You can call the numbers displayed on the screen and ask any question related to immigration, and our attorney will be glad to answer. We'll start taking calls in a few minutes. Before starting the show, I would like to repeat the disclaimer. Please note this show does not provide any legal advice. It is general in nature and it is only for informational purposes. Sakshi TV news and agents are not responsible in any way for your actions. Use of information is at your own risk. Hi Prashanti Garu, how are you doing?
Hello, how are you?
I'm good. Thanks, Prashanti Garu. So before starting the show, let's just recap. If you have any updates, latest updates on the immigration, then we can take it with the I-140 if there are not many updates.
Yeah, there's not much to talk about. There's no updates because it's been basically holiday season, and as we know, the high skilled workers bill, the omnibus bill was introduced, but the high skilled worker bill was not introduced. So I guess that's the only update. So we have to wait for Biden's administration to do something about it, or for the bill to be reintroduced next year. With the new Senate and the new House. Of course, the Georgia Senate elections are very crucial, which is happening in January. And if the Democrats manage to get a majority in the Senate, then the high skilled worker bill looks promising and might get reintroduced and be passed, but we have to wait and see. So there's no update since last week.
Got it. So yeah, today our topic is going to be the follow-up of the last topic, the PERM. So we are going to talk about the I-140. Could you please, tell us about what are the different categories of, I-140 filings, and then we can go to how to file and all the steps.
Right. So first thing is the I-140 is the second step in the employment-based green card process in most instances where a labor certification is required. Except with some exceptions, such as EB1 categories of multinational executives or outstanding professors, except for those EB1 categories where labor certification is not required, usually an I-140 is the second step, because the first step would be a labor cert, which we discussed last week. And the second step is filing the actual immigrant petition. So in the immigrant petition, you have to first of all show that you qualify as per the requirements in the labor cert. So in the labor cert, when you're filing the PERM, you're not really submitting any additional documentation. You're not submitting your educational documents, your experience letters, and other certifications that are mentioned in the labor, because PERM is done online. So it's during the I-140 that you actually submit. For example, if the requirement is a bachelor's plus 2 years of experience, and you have also asked for certification in some software, then what you have to do then at the I-140 stage is go through the PERM, see what the requirements are, and make sure that you submit the beneficiary's credentials. So you'll have to submit, in this case, the beneficiary's bachelor's degree with the transcripts. Make sure the bachelor's degree is, the date on the bachelor's degree is pretty much the date that it was actually issued. So it's not when the bachelor's degree was completed. That is not the date that the degree was obtained. It's the date that, and this is what USCIS has been saying for some time now. It's the date that the degree was actually issued. So sometimes a degree could be issued 5 years later, or 1 year later, or 3 years later, depending on maybe because they didn't pay the fee or to get the degree, or whatever it could be. So a provisional degree is not acceptable. You have to submit the actual bachelor's degree, a copy of it, and the transcripts of all the years, or consolidated transcripts. So if you're asking for a bachelor's in engineering, you have to submit your bachelor's of engineering degree and the transcripts. Now, the date of the degree becomes very important, especially when you do EB2 category, bachelor's plus 5 years of experience. USCIS requires that the 5 years of experience be post-baccalaureate experience. And they look at the date of the degree to make sure that you have 5 years of experience after that. And so oftentimes, the degree might have been received 3 years ago, like in 1996. They completed all the requirements towards the degree, but the degree was only issued in 1990, in 2000. So he may not have 5 years of experience post 2000. So you have to be really careful when you're asking for requirements in the labor cert and when you're submitting documents during the I-140 stage. So if you show a degree that is completed, less than 5 years ago, and you try to show experience that was obtained before the degree, especially for EB2, that case is going to get denied. So that's one important thing with reference to a bachelor's degree to keep in mind. The other important thing is an educational evaluation is always required. So you have to approach our educational credential service and ask them to give you a evaluation of the degree, especially if it's a foreign degree. For a US degree, no evaluation is required, right? The third thing about a bachelor's degree that is important is that the university has to be accredited. So if you went to a university that at the time that the degree was completed, if it was not accredited, and there are many universities that we've had that issue with, right, recently, in the last 5 years at least. And we've received denials because we've submitted a bachelor's degree from an unaccredited university, or a university that maybe was previously accredited, but when this person joined, lost its accreditation, simply because USCIS changed its rules with reference to accreditation. So these things are important to keep in mind. It has to be accredited from a public public university accredited. So there's certain requirements with reference to an accreditation of the university and the degree. And so those have to be kept in mind. In addition to that, if you have asked for 2 years of experience, you have to produce experience letters at the time of filing of the I-140. And the experience letters, for example, if you have asked for, say, experience in XYZ skills, you have to make sure that all those skills are mentioned in the experience letter, because that's the only way of showing that the person actually has experience in those XYZ skills. So the experience letter should have the start date, the end date. So you're saying bachelor's plus 2, right? So it has to show that it's 2 years of experience he has in the letter, whether it be 1 letter or 2 letters or multiple letters. So the start date and end date, the job title, the job duties, and the skill sets. And make sure that the skill sets that you mention in the PERM are there in the experience letter. And if you mention 10 skill sets, all 10 skill sets have to be in the experience letter. If you said 2 years of skill set requirement is needed, experience of 2 years in using XYZ skills is required, make sure that he has or she has a complete 2 years of experience in using those skills. And that is, again, you get that via the experience letter. Now, in some instances, and it may not be possible to get a detailed experience letter from your previous employer because you've already left and there's no one there, or maybe the company closed down, whatever it might be. So in that instance, then you should submit your whatever letter you have, or proof of employment that you have. And in addition to that, you can submit 2 affidavits. Affidavits from 2 different co-workers on stamp paper if they're in India or abroad, whatever the rules are for notarizing, for a notarized affidavit. And if they're here, then simply a notary public will do on a blank sheet of paper signed by a notary public. And the experience affidavits have to have all that information that an experience letter would have. So the affiant or the person who's signing that affidavit must state, first of all, how they know you, in what capacity do they work. Most probably, the best person to give you an affidavit would be a supervisor or manager. And they should say that, give your duties, again, your skill sets. So this is the only way you can prove skill sets now, because you don't have the experience letter. The skill sets have to be mentioned. It has to say that he worked for 2 years on XYZ skills. And those are the same list of skills that you mentioned in your PERM. So that's important with reference to experience letter. Now, if there are other requirements such as certifications, so you asked for Java certification in your PERM, then you have to make sure that you submit that certification when you're, submitting the I-140. So these are the basic, educational and experience documents that you have to submit to the I-140. In addition to those documents, you'll also have to submit, your proof of status documents. You can't file an I-140 unless you're in status. So you'll have to submit your, if you're on a H1, then your H1 approval, your pay stubs to show that you're presently working. If you're on a H4, then your I-539, whatever it might be your status, your I-94. If you're on an F1, then, whatever status documents are required for an F1. So proof of status has to be submitted. Your passport copy has to be submitted. In addition to that, Ranjit, there's another thing called ability to pay, which has to be shown in an I-140. So the ability to pay is basically you're showing that the employer is either paying the prevailing wage that is mentioned on the PERM approval or has the ability to pay the prevailing wage mentioned on the PERM approval. So, for example, if your salary as per your W-2, you will submit a copy of your W-2. If your salary as per the W-2 is 75,000 and your prevailing wage is also 75,000, then you're good. You're already getting paid the prevailing wage, so the ability to pay is already established. But if, for example, your W-2 shows 75,000 and the prevailing wage that was approved in the labor cert was 125,000. So there is now a 50,000 difference. So that difference, you have to be able to show that the employer may not be paying it now to you, but he has the ability to pay it, the financial ability. And that is shown via a tax return. So you have to submit a copy of the tax return.
Prashanti Garu, sorry to interrupt you. We have a caller, Priya from Florida. Let's take the call and then we can continue with our discussion.
Sure.
Hi, Priya. Welcome to the show. You are on the air. You can ask your question.
Hi, ma'am. Good evening. How are you doing today?
I'm good, thanks. How are you?
Yeah, thank you so much for the call, taking my call. So I have a situation where my I-94 is expiring in July 31st, 2021. My employer is planning to file my H1 extension. During my initial H1B, I had qualified for level 2 wage, and now with the effective OWL October 7, 2020, I qualify for level 1. Will there be any possibility for level 1 RFEs, like providing under the same role, same job duties, and same salary?
So do you qualify for the level 1 because your wages have decreased, or is it something else?
No, like previously in 2019 to 2020, my salary was level 2, but now when they revised in 2020 to 2021,
right. Okay. I just wanted to make sure if I wanted to make sure if there's some other issue that I was missing. Okay. So based on the revised, because they revised the wages every year, based on the revised wages, you now don't qualify for level 2, you qualify only for level 1, correct?
Yes, exactly.
That's what you're saying.
Okay. Yes.
So, level 1 wages can be used and should be used only if it is an entry level position. You can't blindly use level 1 or level 2 or whatever it is. There is a certain chart, a table that has to be filled out, and a number system that is given to each thing in the table. For example, if the job that you're doing is that of a, say, programmer analyst or software engineer or whatever it might be, then you have to go to the ONET and see what is the code for that. So just to give you a simple, I don't want to go into too much detail, but for example, for a software engineer, it's SVP 8, Specific Vocational Preparation of 8, which means that basically it's an SVP of 8, which means 2 to 4 years. the DOT code is 8, which means SVP of 2 to 4 years. I'm sorry if I'm confusing you. 2 to 4
No, I'm
years
getting
of
it.
education and experience. So a bachelor's is considered to be 2 years. So you're allowed to ask, in short, for a software engineer, bachelor's plus 2 years. So if the requirement for your position is bachelor's plus 2 years, as per your employer, then then you have to look and see if any skill sets are required. Then if the skill sets are normal, you can just put 0 in that column. So you start off with 1 in the table, and then if your requirements are normal, you can put 0 there. And so there's a table of the requirements versus what is considered to be normal. And so if it's not considered to be normal, then you have to add 1 point there and keep adding points. So when you add points, the default is 1, but if you add anything further to that table, then it becomes 2 or 3 or wage level 4. So that's how the USCIS will look at what wage level it's supposed to be. They will ask for a table of how the wage was calculated, right? So as long as they find that it was calculated, you submit that report in case there's an RFE, and they find that it was calculated correctly, you can use any wage. Whatever, you can use a wage that as long as it's correctly calculated. So in general, wage level 1 is supposed to be for entry level. So a bachelor's plus 2 years or less than 2 years of experience, if the requirement is, then it's considered to be entry level. If you have, for example, if you're a person with 10 years of experience and you've been on a H1 for 10 years, then it seems unlikely that you would qualify for a level 1 wage. But if you just got your H1 last year, say you were a student and you just, got your H1, then it's possible that you could still qualify for a wage level 1. So it's all about justifying why it's wage level 1, tabulating it properly, calculating the wage level properly, and submitting that calculation to USCIS. So 2 years ago, I know they sent a lot of RFEs on the wage levels. But most of those RFEs we were able to overcome by showing this calculation.
Ma'am, do you know what is the name of the chart that you're talking? Like, is there any specific name for that?
It's called, just go to Google and go to wage level calculation for H1s.
Okay.
Or send me an email and I'll look it up and send it to you.
Sure, ma'am. I will contact you of this. Thank you so much. That's the question that I had.
Oh, I think the call got disconnected. Prashanthi, yeah, going back to the previous question, we were talking about the ability to pay. What are the situations when of the ability to pay being in picture when the wages are lesser than that's supposed to pay as per the PERM?
So yeah, as I was discussing, if it is equivalent to the prevailing wage, there's no problem. If it's less, then so for example, in our example, we said that he was getting paid 75 and the prevailing wage was 125. So there's a 50,000 difference in the wages. So now what next? How do you show that even though the wage is not being paid, there is an ability to pay? So you can show this by looking at submitting the tax return. And there are two things to look at, two ways of showing ability to pay in the tax return. One is the taxable income, whatever the profit is that the company made. If it's equivalent to 50,000 or more, then the ability to pay is established. Second thing is you have to look at something called the Schedule L in the tax return. And you have to calculate the net current assets. So for example, if there are no profits, if there's a loss, the next thing you do is go to Schedule L in the employer's tax returns and look at the current liabilities and then the current assets, add everything together and deduct the assets from the liabilities. And if it's a positive figure, then whatever that number is, that is the net current assets. And you can use that number to show that the employer has the ability to pay. So ability to pay, that is an issue. And sometimes There's a lot of case law on this, and it's a very vast subject, the ability to pay. But sometimes, even if there is no net current assets or there is no taxable income, say the company has shown losses in one particular year, but in other years it has shown profit, then there is some case law which can be quoted to show that, the ability to pay still does exist. And that way, cases can still be approved. So, as I said, it's a very vast subject, and we can only talk about ability to pay for the entire session. Each subject is, there has so much depth in it. But we're just doing an overview right now. So I think that what we talked about is sufficient with reference to ability to pay. The other thing that I wanted to mention with reference to this ability to pay is USCIS is asking for a cumulative ability to pay. So say you have filed like 20 I-140s and they haven't received their green cards as yet. So they are asking for each year that that particular employee filed the labor cert, and moving forward, that the ability to pay is established. The cumulative ability to pay. That means for each year, you have to add all the I-140s. You have to add all the salaries of each person versus their prevailing wage. And if they're being paid more than the prevailing wage, fine. If they're not, then whatever that difference is, you have to add all the differences. And you have to show for that particular year that there is sufficient ability to pay via the same calculation that I explained, either through the profits or through the net current assets. And if there isn't, then the employer does have the ability to withdraw some of the I-140s. For example, the person has left them. There's some old I-140s sitting around, the person has left. They can withdraw and say, yes, after we withdraw these, and here's a letter of withdrawing. And as per our Excel sheet, ability to pay is established because we are withdrawing these 3 I-140s. So that's an option that the employer has and can use. Now, another issue about an ability to pay is if you don't have the tax return, because most people file extensions of their tax return, so they don't have the tax return until almost the end of the year. Now with COVID, October is, like the deadline, and it's being extended further. So what to do then? Then you can submit an audited P&L statement in lieu of the tax return. And that has to be accepted also by the USCIS. So these are some of the things with reference to, ability to pay. So the documents are the degree copies, experience letters, documents like W-2s, pay stubs, tax returns to show ability to pay. So these are the documents that you have to submit in an I-140.
Okay, we have, so what is the fee of the I-140 filing, and, what is the process to file? What all documents should be included apart from, you said to show the ability to pay, what are the supporting documents apart from the experience letters, and what all should be kept in mind to make sure there is no RFE and, it's more chances of getting an approval?
Well, I think with reference to documents, we have already discussed thoroughly what documents are required to submit an I-140. But to avoid RFEs, again, I think we discussed because you have to show that the person meets the requirements in the PERM. So whatever the requirements were in the PERM, you have to submit supporting documents with reference to education, experience requirements as per the PERM, skill sets as per the PERM, and also the ability to pay documents. Also with reference to, Ranjit, maybe we can talk about...
one question I had in mind was, you said the ability to pay and all the documents for the employee who is working with the company. You can also, companies also sponsor when the employees are not even working with them. So how does that work, and what things do they have to keep in mind when they are sponsoring an employee that's not even working, or it's a future employee who is about to work?
Right. So then in that case, the ability to pay becomes even more difficult to show. unless the company is a huge company making, a lot of profit. So then they have to show the entire prevailing wage. They'll have to show ability to pay for the entire prevailing wage because there's no W-2 at all. So if the prevailing wage is 125,000, then in that example that we gave, they'll have to show profits of 125,000, taxable income of 125,000, or they'll have to show net current assets of 125,000 to be able to file these petitions. So for a smaller company to file future job employment petitions is very difficult. It's easier if you're a multinational or if you have, lots of profits, or maybe you are filing on accrual basis your tax return, so you have large current, net current assets in your taxes always. Then it's possible. In most instances, it's difficult, especially for small companies.
Sounds good. How about, a lot of companies acquire the, the merge, what happens, when they are in the process of filing an I-140, or let's say after an I-140 is approved, and, employees, what the situation of the employees when the acquisition or merger or anything of such sort happens?
Right. So, a lot of things can happen right after the labor cert is filed, and the I-140 has not been filed yet. One of the things that could happen is that the company is bought over by another company. In that instance, as long as there's a successor in interest situation, which means that the new employer has taken over all the assets as well as the liabilities of the company, as long as that situation is there, and even if that company is in some other state, for example, the perm was filed and the advertisements were done in New Jersey, but the new company is now in California. Even if that is the case, an I-140 could still get approved if we are able to show through the agreement, the sale agreement, that the assets as well as the liabilities of that particular person were taken over. So there could be many instances, many ways that one company purchases another, right? So it could either be that the entire company is purchased. It could be that only some employees of that company were purchased in the consulting company scenario. So if you're showing that only some employees were purchased, obviously this person who you're filing the I-140 for has to be one of those persons. And you also have to show that all the liabilities as well as the assets of all those employees who were purchased is taken over by the new establishment. Same way, if the entire company is purchased, then it cannot be just a asset purchase. It has to be the liabilities as well as assets. So as long as it meets those requirements, and that is shown basically by submitting a copy of their M&A agreement, you can then go ahead and show successor in interest. Another thing, sometimes what happens is the ownership of the company is changed. So the company remains the same, XYZ Corp, but the owners, new owners buy the company. Even in that situation, really nothing has changed in that situation because it still has the same federal ID number. Maybe the company's name has changed, but and location has changed, but nothing else has changed. So in that situation also, it's a successor in interest, and it's possible to file an I-140 now, even though maybe it's at a different location. Third instance, in which some change has occurred. So the company was not bought over by another company, but the company changed its location. So they were in New Jersey earlier, and then they moved to, say, California. In such a situation, unfortunately, the labor cert has to be refiled. You cannot file an I-140 because the market was not tested. Unlike a successor in interest situation where they allow you to file, even though the location has changed, if it's just purely change in location and no M&A has taken place, since the market was not tested, and since it was done specifically for the New Jersey market to see whether there are any available applicants, and California market was never tested, you'll have to again refile the labor, and then only you can file the I-140. Now, there's an exception for this if the location has changed, but the change is within commuting distance. It doesn't have to be within the same metropolitan statistical area or MSA that is prevalent for H1s, but it has to be within commuting distance, which is a little bit more lenient than being in the same MSA. As to what is commuting distance is, of course, something that can be argued. Within a day, you should be able to commute back and forth to work. So that is, within commuting distance. So you can argue that it is within commuting distance, I guess, if it's neighboring states, like New York, New Jersey, Pennsylvania, Connecticut, etc. So that's something within about a 50-mile radius, maybe. So that's something that has to be kept in mind. That's the second change that has to be kept in mind with reference to filing an I-140 after the labor cert was approved.
Okay. Can you explain the timeline of the I-140, a rough timeline? I know it's always changing, and if there is any premium, so what is the fee and all? Could you please explain?
Well, yeah, I-140 processing time keeps changing. You have to go to the USCIS website every time to see what is the processing time. It's usually 4 to 6 months. With COVID, everything has changed. If you want to file premium processing, you have to file the 907 form. You can either file that along with the I-140 application, or you can file that after the fact. Once you've received the receipt, you can file it, convert it to premium processing. They've recently changed the fees for premium processing. It is now $2,500. So they've increased it. And also what they've done is increase the time within which they need to respond for premium processing. It used to be 15 days before. Now it's 30 days. So that's another change that has occurred recently with reference to premium processing. Yeah, but if you don't file premium, maybe 4 to 6 months is the expected turnaround time.
Who can pay for I-140? There are a lot of confusion. Few say employee can, and few say employer can, and only employer can do that, not employee. So can you throw some light on who can pay the fees for the I-140 filing?
So for the I-140 filing, the employer is supposed to pay the fees, not the employee. But it is not statutorily by regulation that the employer has to pay, in the sense that they will not accept a check from the employee. That's for sure. If you send a check from the employee for the fee, the case will be returned because it's an employment-based petition, just like a H1. But the question here is, can the employer ask for a reimbursement of that fee from the employee? And that is a gray area. And usually we discourage employees from doing this because, there have been many scandals with reference to green cards where employers have sold green cards to employees. And, it's taken $10,000, $20,000 for, to file a green card. And they have, then been audited, and there's been criminal investigation against many employers for doing this. So it could present a situation of fraud. It could look like fraud. And you don't want to do anything that looks like fraud. So we always ask that the employer pay for the entire green card processing. But unlike the PERM, where by regulation itself, they have amended the regulation and said that the employee cannot pay by law. They have not said that for an I-140, but it looks bad. So when the employer pays or asks for a reimbursement. So I would suggest that the employer pay and not the employee.
Yeah, this question is being raised, especially when people file it concurrently. Most of the employers ask directly to pay the attorney or whatever the whole fees. I believe 485, 765 and all can be paid by employee, right? So,
well, the attorney can accept the fee because that could be reimbursed again, right? The employer could reimburse the fee to the employee. So that there is no issue with the attorney accepting that fee. That is there's an arrangement between the employer and employee for that. Now, the attorney is not allowed to accept a perm fee. That's by regulation. In I-140 situation, the attorney has no, will have to, of course, give proper advice as to, who should pay and for what reason. But there's nothing to stop them from accepting the fee, because that could be reimbursed, and oftentimes it is, by the employer to the employee. Because in the interest of, like, for example, during this October bulletin season, there was not much time, and a lot had to be done. So it was difficult to get checks from different places. So it's possible that attorneys might have accepted fees from the beneficiaries, and the beneficiaries were after that reimbursed. So yeah, that is a different situation, and I don't see any issue with that. But I think that no matter what the situation, that reimbursement, it's better for the employer if that happens, because then it's questionable as to whether an actual job offer existed, or they were just doing this, they were selling the green card, So the look of it is also very important. It shouldn't look improper, and then start and be a cause for some kind of an audit. So that's very important to keep in mind.
Got it. So, but 485 and 765, I believe it's completely fine, right?
Yeah, that is a 485. So, and anything to do with the 485 is completely, it's a beneficiary-driven petition. The employer really has nothing to do with, except for the 485J, which they have to sign. They have nothing to do with the 485. That's signed completely by the applicant. Sounds good.
For the viewers, if you want to reach the attorney Prashanthi for a private consultation, please reach at 212-354-1010 or prashanthi@reddyesq.com. Again, I would like to repeat the disclaimer. Please note this show does not provide any legal advice. It is general in nature, and it is only for informational purposes. Sakshi TV news and agents are not responsible in any way for your actions. Use this information at your own risk. Yeah, Prashanthi, going back to the I-140 thing, what happens when the I-140 is denied? Do they have to do all the process again? Or, could you please shed some light on how it works?
Right. So now we have filed the I-140, and perhaps, most probably maybe an RFE was received, and that RFE could be with reference to ability to pay, or it could be that, the degree date. Remember, we talked about the date of the degree. It could be because of that, or it could be it's not that the university was not accredited. There could be so many reasons why an I-140 gets an RFE and then is ultimately denied. The new reason is now they're asking for right to control, employer-employee relationship in the I-140 also. They're asking for to show that there's a valid job offer. So they're asking for contracts, agreements, to show that, that business is good, and that there is the likelihood that, this is a valid job offer. So it could be denied for that reason as well. If you don't submit proper documents, it could be denied upon RFE for ability to pay also. So there are many reasons why there, could be a denial. But once you get a denial, then there are two things you could do. You could appeal, which may not be useful because an appeal is very rarely overturned. Or you could refile the I-140 if you're able, depending on why it was denied. For example, if they deny it based on the fact that you don't have your bachelor's degree was completed much later because you got the degree later, and so you don't have 5 years of post-baccalaureate experience, and you don't qualify for EB2, and you filed under EB2, and that was the only reason for denial, then you can refile using the same labor, another I-140, and this time you ask for EB3. So it's the same labor, same requirements. You're asking for EB3 so that you don't have that bachelor's plus 5 years post-baccalaureate experience issue, right? So you could refile it. Maybe the case was denied because you were not able to show ability to pay for the current year because the tax returns were not yet filed. And, the P&L statements were not audited. You were not able to submit audited P&L statements. You could refile because, maybe by the time you refile, the tax returns have been filed, and so you can refile with those tax returns. But there's some instances in which you cannot refile because the PERM itself is the problem. So there's some requirements in the PERM that you have put that the beneficiary is not able to show. For example, maybe you put XYZ skills in the PERM, but the beneficiary was not able to get an experience letter. Or you put a bachelor's requirement in the PERM and the beneficiary does not have a bachelor's from an accredited institution. Then you cannot refile the I-140. Then you'll have to refile the PERM itself. And then this time not ask for a bachelor's degree, but ask for just experience and redo the PERM under EB3. So it really depends on the circumstances, whether the issue is, whether that evidence or the reason for denial can be rectified by simply refiling the I-140. Now we have to remember also that when you're refiling the I-140, you're filing it with a duplicate approval. So, and it's also most probably beyond the 180 days. Now a labor cert is valid only for 180 days. You cannot file an I-140 after that. But in the case of a denial and refiling, the 180 days doesn't apply. So, you're good with reference to that. You can just refile and show clearly in the refiling that you're submitting it with a copy. You have to put it in the cover letter in bold. Otherwise, they'll return the I-140. That you're submitting it with a copy and you don't require Department of Labor to submit a duplicate because the USCIS already has the original with them. So these are some things to keep in mind when you refile.
Okay, got it. So another question here is, current experience may not be used for the green card. It's always before the current job, but a lot of people might have been working with the same company for like 6 years, 10 years as well. So there is something called progressive experience. Could you please shed some light on what it is and how it can be used?
Right. So Ranjit, that's not progressive experience, but I understand what your question is. So you're basically asking me that suppose they don't have any previous experience. So can we then show a requirement for, say, bachelor's plus 2 years of experience? That is only possible if, for example, the experience that was gained through the petitioning employer is substantially different from the present petition. So say you have to show 50% of difference, then only you can use experience gained from the petitioning employer. Otherwise, you have to show that as of the date of joining, they already had that experience. So when we say 50% difference, let me give you an example. So you're filing for, say, a programmer analyst position. And you're asking for 2 years of experience, bachelor's plus 2 years of experience in a related field. And you say that person has worked for 2 years, but the experience has been only with the present petition. And say that position is that of not a programmer analyst, but something a little different. Maybe a data analyst, just for the sake of, giving you an example. So you have to show that the experience of the data analyst is at least 50% different from that of a programmer analyst, the job duties. So you have to make a table and show the differences. You have to document it clearly in the PERM. In that instance, you can then use the experience gained as a data analyst and say bachelor's plus 2 years required in the same job or in a related job, and then you can file the PERM. It is possible to do that. You want to avoid doing it if it's not necessary, but if it becomes absolutely necessary, then yes, that can be done. Another issue that comes up with the person not having any prior experience, and this is often the case with a lot of F1s, right? They join a company and then immediately they file the PERM with that company and they've not worked for any other company. When we ask for skill sets, So say we say bachelor's plus 2 years of skill, 2 years of experience in XYZ skill. If I don't ask for skill sets and I just ask for bachelor's plus 2 years of experience, everybody will have bachelor's plus 2 years of experience. So when you file the advertisement, you'll get tons of resumes. You will not be able to disqualify them, then you cannot proceed forward. The only way to proceed forward is to make sure that the duties are clearly defined and are very specific with reference to the skill set requirements. But if the skill sets were with the same employer, then it's difficult to show. So in that instance, I can say that instead of saying 2 years of experience in XYZ skill, I can say knowledge of XYZ skill. Now, knowledge can be gained through education. It doesn't have to be through experience. So that's one way of overcoming the lack of experience, previous lack of experience. So you could have had a certification in XYZ skills. So I can say certification required. Or you could have done those XYZ skills in your when you were doing your bachelor's, and you can show it that way. But remember, the certification should have been obtained before they joined the petitioner, not after they joined the petitioner. So this is another way of still showing skill sets as a requirement, even in the instance where the beneficiary does not have previous experience.
Got it. Another case is where, people have lots of experience, but earlier in the days, people only did 3-year degree. So, how to handle that? Let's say the candidate has like 20-25 years of experience in the IT, but has only a diploma or a degree, like a 3-year degree. Can a green card be filed at all in any of the categories? If so, what category do they come under?
That's a good question. Yes, there are many instances in which the 4-year bachelor's degree is not there, because if they have an engineering degree, then even from India, then it's always a 4-year degree. But for example, if they have a BSc in computer science, then it's not a 4-year degree, it's a 3-year degree. And if you then say, without realizing it, that bachelor's plus 2 years is required, that I-140 is going to get denied. And then there's no purpose in refiling it. You'll have to refile the labor and change, update the requirements, revise the requirements. So in the instance where they have a 3-year degree, it's not equivalent to a bachelor. So you cannot ask for, and obviously the person was hired. So that means the minimum requirement initially also was not a bachelor's. Otherwise they couldn't have been hired, because 3 years is not a bachelor's. So you should ask either for an associate's degree plus whatever, experience. So it really, how much you ask for depends on what the job title is, what is normal for the job position. If you're doing a programmer analyst, and just simply because the person has 20 years of experience, you cannot ask for 20 years of experience. So if you do, then you will get the labor cert itself will be audited. The perm will be audited, because you're asking for requirements that is beyond the industry standard. And that is determined through the ONET, as I was talking about SVP and the code, job zone 4. Each job title has a job zone, and they say what are the minimum requirements. So if you ask for more than that, then you have to justify through business necessary document as to why you're asking for more than what the industry standard is. So in the case of our friend who doesn't have a 4-year bachelor's degree, you ask either for an associate's degree, plus experience, or you just ask for experience. Ask for 4 years of experience. If it is somebody who has an SVP of 8, such as a software engineer position or most of these IT positions, the SVP is usually 8. In that case, you can ask for maximum of 4 years of experience. So you can ask for 4 years of experience, and that's what I usually do. And then you can ask for skill set requirement. You can say XYZ skill experience required for 4 years. And in that instance, then those people will not be professionals. EB2, EB3, there'll be EB3, but not EB3 professionals, but there'll be EB3 skilled workers. But both the EB3s, the priority date is the same, so it really doesn't matter. So if you ask for more than 2 years, or at least 2 years, the The category is 1F, which is pretty much skilled worker. Anything below a bachelor's degree. If you ask for an associate's degree also, the person becomes a skilled worker. It makes no difference really from the priority date point of view or approvability point of view. It's easier, in fact, for the case to get approved.
Got it. So how about a person who has a bachelor's 4 year but then no experience? Can they also file for a green card in the same skilled category?
Yeah, so you can file in the professional category there in EB2 under 1E, a professional. You can file under that, not the skilled worker, because here a bachelor's degree is required. Yeah, because only a bachelor's degree is required for a professional. You don't need to put any experience at all. But the issue occurs, what happens is then, how do you disqualify the resumes that come in? Everybody has a bachelor's degree. So if you're not asking for skill sets or experience in skill sets, then it's difficult to disqualify resumes. Then you'll have to do what I said earlier.
Yeah. I mean, we are talking about a situation where, as we were discussing, either masters or bachelors, people join as a fresher and they continue they've been working probably for a couple of years or 3 or 4 years, but then, as you were saying, the current experience may not be used unless it's completely a different 50-50, whatever. So
right. So in that instance, then so to overcome that, as we discussed also, which I was going to say, is we have to show that the person has knowledge of those skills and not necessarily experience, maybe in the form of certifications, or there's still ways of doing it. So we can show it that way also. And just say bachelor's degree, no experience, knowledge of XYZ skill.
Okay. That sounds good. So yeah, other question a lot of people have is, especially for India, as well as some other countries like China and Philippines, the dates are not current. So people who have been working in the same company for about 10 years, whose I-140 was filed like before 10 years or whatever, but then they have changed lots of designations throughout their career in the last 10 years. When it was filed, probably they were a programmer or a developer, and now they are like probably a project manager or a VP or some other positions. So how to handle these situations? So can the I-140 be amended, or it comes in picture when especially the date becomes current, how to handle those situations?
So USCIS has consistently said that a 485 can be filed even if the job duties change, as long as the change is not significant. So simply an increase in their responsibilities, as long as the skills remain the same, the increase in their responsibilities doesn't necessarily mean that the 485 will be denied. So simply because they're receiving more wages or they have a more supervisory kind of role, that is fine. You can still file the 485 without having to refile the labor and go right from the beginning, have to start everything all over again.
Okay, that sounds good. Other situation is similar kind. Employers change their locations, sometimes maybe within same MSA, sometimes not within the same MSA, and sometimes maybe out of state. In those situations, can they just amend the petitions, or what process need to be followed for each type of scenario?
Right. So as I discussed this before, this scenario, if it is within the same, if it's within the same commuting distance, then you're fine. But if it is outside of that, then you cannot file an amendment. You have to refile, Ranjit, you have to refile the labor cert pretty much in that instance. So
okay. Let's say if it's just within the same state, but different, probably
then it's
other
fine, as I said.
State.
Then if it's same state within commuting distance, then
not even an amendment is needed.
Nothing is needed. You can just file the I-140 and in the cover letter, just write and say that location has changed, but it's within the same county or state or commuting distance or whatever it might be, and therefore we are filing this petition.
Okay. And going back to the previous question where the change in the designation thing, can they amend? I mean, let's say someone wants to amend because they have been promoted or whatever. Can they just amend the I-140, or do they have to again?
No, you cannot, because you cannot amend the job title. You can, when you're talking about amending an I-140, you can only amend the category within which you're seeking to file, if you qualify. And that is basically between EB1, EB2, EB3. You can not even EB1, between EB2 and EB3, you can toggle when you do an amendment. Also, you can amend in situations where there's been an error. Right? There's a mistake in the I-140. Maybe you didn't include the family members. Maybe you didn't ask for the priority date to be retained. Those are situations in which, an I-140 can be amended. You cannot amend to change the job title.
Okay, yeah. Coming back to the last one you're talking about, the upgrades and downgrades. Can you just tell about, what is an upgrade, what is a downgrade, and how does it work? These days it has become very common for the downgrading, especially because the EB3 dates have advanced a little bit more than that of EB2.
So in a situation where you need to downgrade, there are two ways you can do it. You could either file a new petition. In part 2, there is a column in the I-140 form in which you mention if you want to amend the petition. So an existing petition can be amended by ticking off that box and giving the previous receipt number. When you do that and you amend it, say from EB2 to EB3, you have lost your EB2 priority date or I-140 approval. Now you only have an EB3 I-140 approval once the case gets approved. If it gets denied, then of course status quo is maintained. But if you want to keep both the I-140 approvals, then what you need to do is not amend it and just file it as a new petition. And just write in the cover letter that we're filing a new petition based on the same labor cert, and we're filing this petition under the EB3 category. So then what happens is you're maintaining your EB2 I-140, you're maintaining your EB3 I-140, you have two I-140s with the same priority date. And based on which one is more conducive, you can file the 485 based on that. Say you file the 485 based on the EB3 now because EB3 is moving further. In the future, if the EB2 movement is faster, then you could prospectively then inform USCIS that you would like to basically interfile your existing 485 with the EB2 I-140. That's also possible, and they can just then maybe then your 485 will become current and it could also get approved. So this is the advantage of maintaining both, because then you could toggle between the EB2 and EB3 based on which visa number has become current.
Okay, got it. If someone wants to file both EB2 and EB3 with the same labor, is it possible?
Yes, that's what we're talking about. We're talking about the same labor, and we're talking about having two I-140s based on the same labor certification.
Got it. Okay, Prashanti garu, we have reached towards the end of the show. If the viewers want to reach the attorney Prashanti garu for a private consultation, please reach her at 212-354-1010 or prashanti@reddyesq.com. Thanks for all the calls and watching the show. It was a great session with interesting topics and questions. Please call in every Wednesday at 5:30 p.m. EST to watch the Immigration Talk Show. Again, it's every Wednesday, 5:30 p.m. EST and Sakshi TV. This is Ranjit signing off. Thanks, Prashanti.
Thank you.